We're going to go on the record in the Warren matter. Petitioner appears in Ms. Locke's office. The respondent appears with her counsel, Mr. Olson, in his office. All right, so this case is back in front of me on a, I guess, motion to modify custody. Correct, Mr. Olson?
Yes, ma'am.
You know, I've got to find that any modification of custody is in the child's best interest. There is a question about this case meeting any kind of threshold prima facie level. I'm not sure about the material change of circumstances. Have to look at that again, but last I checked, it required essentially, or there's an argument that it requires full custody litigation in an evidentiary trial format for it to apply, which I think is a little silly, but that's what I thought we determined today. But I think there were some exhibits that were presented a little late for Ms. Locke to really, in all fairness, have a chance to review. I will tell you where I'm at, counsel. This is where I am on this case. I am inclined, and I'm not prejudging the case, but I am inclined to send these two back to Paula Langworthy and have her go through the very detailed parenting plan that she worked up with them and see if there have been any genuine violations of that plan in any significant regard, and hear from the parties and give the court an opinion as to whether or not she believes that there's been any kind of change of circumstances that would warrant reconsideration by the court. That's what I'd like to do, because there are a lot of allegations here, and I think that you have to take each allegation. I think you have to look at it in light of the parenting plan. And then I think you have to hear from each side. And then I think you have to determine whether or not there is an actual breach of anything. And as far as the child's concerned, she's not old enough to give input. I will tell you the other thing I'm concerned about, Mr. Olson, is a lot of these issues she's raised are really pretty re judicata. As previous matters that were brought up prior to the final divorce settlement. They may or may not have been fully litigated, but their complaints that were on file with the court and have been voiced by her numerous times. So the only thing that I am not sure of that I would have to very carefully examine, I'm not sure I've ever seen, I don't know if it's in these exhibits, is there have been allegations that he's purchasing liquor, and that after the trial was over, she got to go through some of his finances and discovered that. That may be the only new information that she didn't have a chance to bring forward or produce. But that's where my thought process is at. But I'll let you respond, Mr. Olson, and then Ms. Locke.
Yes, ma'am. And I would tend to agree, Your Honor, unless the court's wanting me to. I'm not going to go through an itemization of our 17-page motion to modify. There's also been a couple of responsive pleadings filed with respect to that. So obviously the court can read those if it feels the need. I would say a couple of things, Your Honor. The court is right. These parties did go, and there may be a couple of things I'm not absolutely precise on as well, Your Honor, because I didn't get involved in this case until later on, where a lot of this or some of this litigation had already occurred, so I wasn't present at the time, which as the court I know well knows always makes it a little bit difficult. But regardless, these parties, as the court knows, went to see Ms. Langworthy last year, and there was an agreement reached on August 1st of 2024 that adopted Ms. Langworthy's recommendation. As part of that recommendation, there are a couple of aspects to it that I think are very important for the context of this hearing here this morning. And that is Ms. Langworthy put in there that if the petitioner has one positive alcohol breathalyzer, one positive alcohol result, that the respondent shall be allowed to go pick up the minor child, even if it's during the petitioner's parenting time, and keep the child until such time as his next parenting time starts. And then he shows that there's been a negative a breathalyzer test. It was something that was in place during the pendency of this case and was contemplated by Ms. Langworthy's recommendation, Your Honor, that there would be an ignition interlock device attached to petitioner's vehicle. He has also at times done handheld breath tests and sent videos to my client prior to his parenting time. As the court well knows, there's been issues with alcohol throughout the duration. Again, understanding these according to my client, but alcohol abuse by the petitioner, allegations of that. I believe that petitioner's position has been is he's been sober since November of 2002. So fast forward, we get to August 1st, 2024, where this agreement is reached. At that time, the information that we have provided through either these bank statements and or these breathalyzer tests for the ignition interlock device that was attached to one of the vehicles that the petitioner drives, none of those were available to the respondent, nor had they been requested. That agreement was reached August 1st of 2024. We moved on. There was a pre-trial date, I think, that we all had, but this time I was involved in the case. Again, this is where things get a little fuzzy, and there's a point to this, so I'm not trying to waste time. But the court had made some pretty cut and dry orders sometime, I think either that August date or a subsequent date before I got involved, that discovery was closed, so on and so forth. So we got to, I believe, either a status conference or another pretrial conference hearing where I had at that point gotten involved. And we had requested through some business records subpoenas to ask for and be allowed to issue those subpoenas with respect to these bank statements that we've provided, as well as these ignition interlock device readings. The court allowed us to issue those, but I believe that was not done until roughly November or December of 2024. At that time, we had already had a trial scheduled for January 25th and 26th, or 26th and 27th, and whatnot. And the court, who had already, I believe, the trial date had already been continued once or twice before my involvement, had said, and I completely understand, hey, we're going to trial in January. If you want to issue these additional subpoenas and get this information, that's great, fine, and well, I'll allow you to do it, but we're not going to move the trial date. So long and short, that information was not received back by the time the parties got to trial. We had a trial date. We were able to settle the outstanding financial issues that the parties had. We did not address anything at the trial agreement relating to residency and parenting time, because the understanding was that on August 1st, that had been agreed to in the Paula Langworthy's recommendation had been adopted, but for maybe some child support and health insurance benefit stuff that was contemplated in the journal entry of judgment decree divorce. So why I say that is because, as the court has noted, there are bank statements and two breathalyzer readings that are of pretty decent concern in my book, that have shown that petitioner, although that he has represented to the court that he's been sober since November of 2022, has still continued to purchase alcohol. There are two breathalyzer readings, one from October and one for November, that show that, make sure I've got the readings right. On October 1st of 2024 at 6:53 in the morning, he registered a .068 on his interlock device in his vehicle. And then on November 4th of 2024, he registered a 032 at 7:13 a.m. on that interlock device. There are no readings after November, because I believe the petitioner quit using it, even though that was also part of Ms. Langworthy's recommendation, that I believe once the recommendation was adopted, petitioner was to keep that ignition interlock device on his vehicle for 6 months. and he didn't have any readings in December. And why I mentioned December particularly is because of, at least from the statements we provided, there were 4 dates between the two bank accounts that through Bank of America that were provided 4 times where petitioner purchased alcohol. It's clear cut. It's
Your Honor, I'm sorry, but I'm going to object to any reading of bank statements into the record and any supposition that that was a purchase of alcohol. This is not an evidentiary hearing, and this appears to be attempting to sway the court to make favorable findings to the respondent without actually putting on evidence.
Well, I'm not going to do any modifications. I'm just letting him argue. I want a very clear picture of what the actual argument that they believe that they can prove up is. So go ahead and finish. I'm not wanting you to elaborate too much, but I think you are being very particular as to what you believe you know now that you didn't know then. Go ahead.
Yes, ma'am. And that's
not accepting it as evidence.
Certainly, and I understand, and I do, just for so the record's there today, I understand Ms. Locke's frustration with the allotment of exhibits we had yesterday. My anticipation was, from reading the prior email from the court, this was the proverbial put your money where your mouth is. This motion's on file. I want to know what you got, because I'm going to look at it, pursuant to KSA 233219. So that's why I took the steps to do it. But regardless, I won't get into much detail. But there were alcohol purchases in December. There's actually alcohol purchases that date through a lot of 2024 on these bank records that we had provided. Just regardless, those are that's the concern with respect to those. More importantly, back to what we got a little sidetracked on from about 5 or 10 minutes ago. The 2 positive breath tests on the Interlock device, I think, are more concerned because, pursuant to Ms. Langworthy's recommendation that's been adopted on a second violation, the recommendation is, and this is where I think it makes the court's decision on whether or not we've met a prima facie case to bring anything forward with this motion. But on a second offense, the petitioner's parenting time is to be suspended until further order of the court. And so we've got 2 of those. We've got 2 of those documented. And so looking at this as far as, raised judicata, tell me why the things have changed, or why is something different when we had an agreement not even a year ago with respect to residency and parenting time. It's, as the court's already noted, none of this information was available at that time. And 2, petitioner by his own actions has violated Ms. Langworthy's recommendation to the extent that her recommendation would suspend his time until the court made a further order. And so that just being the main focus, and I do understand, Your Honor, there are other issues that are pointed out in our motion. Some of those are for context purposes. I wholly understand and frankly agree. Things that occur prior to an agreement on parenting time really are not that relevant for purposes of where we are today. I do think they provide a little bit of context. And again, I took a little bit extra time drafting such a lengthy motion because I was anticipating we would be having this conversation or type of hearing today where, again, the court's going to go, why in the hell, excuse my language, am I going to open this back up or do anything with residency and parenting time? So there have been some other communication issues between the parties, again, that we've alleged in our verified motion. One issue that I also think is important that the court needs to know is that in May of, I believe it was this year, there was the petitioner was involved in a car accident, or perhaps it was 2024. I'm sorry. So regardless, there was a prior car accident in May of 2024 that is a little bit more concerning now. Well, because given the fact that there are some alcohol purchases in or around the time that the petitioner would have been in that car accident, the minor child was riding with him. And so it has been and still continues to be a very big concern for my client that petitioner is driving the minor child while he has or previously has or is drinking. Again, I'm not going to sit here and tell the court that I know or the exact science behind how alcohol dissipates in your system, but having a 0.068 breath reading at 6:30 in the morning would indicate to me, because obviously the body would have metabolized some alcohol from the previous night, that there was probably some fairly decent or heavy drinking being done, at least on that particular occasion. And so we have the bank records through December of 2024. If I had to speculate, there's probably going to be more on there if we had them through current. But that is the proverbial gist on the major issue and concern that we have, Your Honor. And again, as part of our motion, we've asked for a guardian ad litem to be appointed. I understand the court's position on domestic conciliation as well. The one thing I would also note, just for a clarification, that, and again, this was my understanding of it. I was not the attorney of record at the time, but when the parties were originally referred to Ms. Langworthy, which I think was maybe around March or April of 2024, there was already a representation at that time made, or the parties had already agreed, quote unquote, to the shared schedule. And during the domestic conciliation process, my client had some current concerns that she wanted to voice to Ms. Langworthy about having the shared schedule. And Ms. Langworthy said, well, hey, look, I understand your concerns, but the order from the court does not allow me to look at that. I had specific orders as to what my purpose is with particulars for this case, and residency and parenting time are not one of them. So again, for purposes of this hearing, I do think it is relevant when the court's looking at this, whether or not we have met a prima facie case, looking at prior facts and whether or not there's I think it's arguable whether or not we've got to show material change of circumstance. I think the court was mentioning that initially. This wasn't, again, based on my understanding and looking at the court pleadings, the August hearing date was not a full-blown evidentiary hearing where the court heard witnesses' testimony and then made findings of fact and conclusions of law. So arguably, I don't think we even have to meet that standard in order for this motion to move forward. Regardless, if the court still wants to look at it, which is why I drafted the motion the way I did, there should be a material change of circumstance. I think we've absolutely met that threshold standard. But again, in the context of that, Ms. Langworthy's recommendation, arguably, or her purpose, the initial appointment time didn't really even deal with residency and parenting time. It dealt with more of some of these other parameters that she had set out for the petitioner to alleviate concerns of my client before his parenting time and driving the minor child and so on and so forth. So I think that's also relevant that there's not been a domestic conciliator who has been appointed to look at residency and parenting time issues specifically, because that was not within the purview of Ms. Langworthy in the previous time that she dealt with these parties. So again, Your Honor, with the access that we've had to the information that we've obtained, the fact that, again, per the DC recommendation, frankly, petitioner's parenting time very well should have been suspended until further order of the court. Per that recommendation, I believe that we have very much met the standard of a material change of circumstance. We're absolutely asking that the court refer this case out. Again, our preference would be for a guardian ad litem. I understand where the court is at. We had asked for Ms. Campbell as a guardian ad litem if the court's inclined. Obviously, the court's going to do what it wants to do with domestic conciliation and Ms. Langworthy. But regardless, something needs to be done because we do have a 6-year-old girl here that is potentially getting transported with somebody that's maybe under the influence. And I know it's a very, very big concern for my client, amongst all of some of the other continued communication issues and whatnot that the parties had that I haven't gotten into a lot of detail to.
All right, Ms. Locke.
Thank you, Your Honor. So I would like to operate in fact for a moment, and that would be just a look at the record. And that's what I provided the court. My understanding of this hearing was that we were to establish with the court why there should not be any further consideration of this motion, and whether or not this even needed to be set for a pretrial. What I provided in our Exhibit 1, which was timely provided pursuant to the court's guidelines on when exhibits have to be provided, is just a timeline of events that have occurred in this case. So while I appreciate Mr. Olson's rendition, it is not completely accurate. So the parties were ordered to DC, and Ms. Langworthy they were ordered to DC in 2023. They participated in DC, and Ms. Langworthy issued her report in February of 2028. Report and recommendations were filed with the court. Ms. Warren, her counsel at that time requested modifications to the recommendations and asked the court to review the recommendations. They filed a motion in March 19th. We filed a response, including exhibits that essentially what my client repeatedly says is debunked the accusations that were made in that motion to review the recommendations. The court had an in-person hearing on May 2nd on this case to review the respondent's objections to the recommendations. At that in-person hearing, everyone was prepared to provide evidence, to have testimony. The court took the case up by proffer, and the court did make modifications to the recommendations. I was ordered to draft that journal entry. I drafted it, sent it to respondent's counsel, and then there was no response. Ultimately, the court had to have a hearing on the journal entry. During this time, discovery is open. We're proceeding on the case. But the journal entry resulting from that May 2nd hearing was not resolved until the pretrial conference on August 1st. Not as a result of anything that either of the parties were doing, but simply as a result of respondent's prior counsel refusing to participate in adopting the journal entry. From May 10th until August 1st, the parties were
Well, we don't know for sure that she didn't give him authority, that she didn't like what he was doing or failed to do or didn't get records, or she didn't like the direction things were going, and she objected to him signing off on the journal entry. I mean, we don't know that it was just he dug his heels in and just wouldn't finish his job. But go ahead.
Honor, the journal entry itself stemmed from the hearing. So there was no ability to say we can't record what happened at the hearing. It was the language that was being used about how to define a caregiver that was the objection. That resulted in this delay from May to August on the parenting plan journal entry, essentially the adoption of the DC recommendation. However, the parties followed the recommendation during that entire time. We had a pretrial conference on August 1st. That was a hearing before the court. No issues were raised about the DC recommendation or report. And more importantly, neither pretrial questionnaire contained any concerns about parenting time. During this same period of time, this allegedly horrific, which it is not, car accident occurred, again, not raised in any of the pleadings, not addressed in any of the pretrial. After the pretrial order is issued, we have a change of counsel that occurred. So the trial date got pushed out. We were supposed to go to trial on this case at the end of October or the beginning of November. There was a new trial date set on November 5th. We were before the court for a status conference. Again, no concerns about parenting time raised. The court can make decisions in the best interest of the child at any time, yet we were before the court, no concerns are brought up. Then we were before the court again on a motion to compel discovery. That occurred on December 11th. No issues brought up about parenting time. Then we had an in-person trial in January. No issues about parenting time addressed, with the exception of a few requested modifications of the parenting plan, including international travel and notification for international travel, as well as what countries the child would be allowed to travel to. We file the journal entry. There's an objection to the journal entry and the contents. So we had another hearing with the court on April 11th. That period of time is significant because from January to April, the records were produced that are being addressed here. All of these records were made available, the interlock records, the bank statements, yet at our hearing before the court on April 11th, there is no mention about any issue with parenting time. The only discussion of parenting time in a hearing before the court is whether or not the child will be allowed to travel to Africa. That was essentially one of the biggest issues that we dealt with on that date, in addition to the things Mr. Olson mentioned, including parenting or child insurance spouse or child support, those items. So we've been before the court 1, 2, 3, 4, 5, 6, 7 times since the DC recommendation, once about the DC recommendation, and parenting time, custody, residency has not been addressed other than the minor changes, despite the allegations that during this entire time, all these issues have been arising. So that's our concern number one, is if this was a big deal, it should have been addressed previously. The second concern of ours is in the DC recommendation, Ms. Langworthy's statements on page 3 of the recommendation. This is paragraph or section 5, paragraph B. It specifically states that father has to maintain an interlock device in his vehicle for a period of 6 months beginning immediately upon filing the DC reconciliation report and recommendation. My interpretation of that was it happened immediately upon her filing that with the court. As a reminder, at this point, my client had already had an interlock in his car voluntarily since August. So he had already had the interlock for 6 months, and Ms. Langworthy was saying he needs to have it for another 6 months. And then after that 6 months, he moves to a handheld breathalyzer. Her report specifically says immediately upon filing the DC report and recommendation. That happened in February. We agree that the court did not formally adopt the recommendation by an order until August 1st, but as we've discussed here today, that timeline was skewed not as a result of an objection to the interlock, but as a result of an objection to the definition of a caregiver. So that's one concern. The other concern is there is a built-in remedy for the respondent. There's a built-in remedy in the DC report, and she chose for 18 months now not to use that remedy if she had concerns. We believe that if we went to evidence on this, it would show that my client is not in violation of her recommendation. However, even if he had been, she elected for 18 months not to use her remedy, and instead her suggested remedy is that my client go from equal parenting time to no overnights. That's not a remedy proposed by Ms. Langworthy, and it's not the step that was proposed and agreed to by the parties. The respondent has never elected to use the remedy provided by Ms. Langworthy. Instead, her goal is to go back to court and get what is arguably, I mean, for sure, not in the best interest of the child, to completely eliminate my client's overnight parenting time and parenting time in general.
Remind me what her remedy was. This is about the thickest file that I've got pending right now.
So, Your Honor, in that same paragraph that I was just reading from, during his parenting time, the father must test each time he drives his vehicle at a minimum 2 times per day, once in between the hours of 5 a.m. and 10 a.m., and once in between the hours of 5 p.m. and 10 p.m. So this was essentially during his parenting time, he has to test if he's going to have parenting time that day. If father has blown a BAC of 0 each time he utilizes during his parenting time, then we move on to the next step. However, if he fails, let's see. Should father miss a window for testing? So this is subparagraph F. It's on the following page, page 4. Mother will be allowed to immediately pick up the minor child from the father's care. So if he missed or failed a test, which she's getting the videos of these, then she gets to immediately pick up the child, and my client's parenting time does not recommence until he has a clean UA. So it's not another breathalyzer test, but it's a clean UA and a breathalyzer test when his parenting time is going to start again. She never elected that remedy. She never said, hey, you failed to send a video. I'm coming to pick up Isabel.
Okay. Remedy.
So
and I suppose there could have been a contempt of court potentially as well. Amy, I know that we had a case similar concerns of alcohol where we blacked everything out, but gave them Ms. Langworthy's sort of stair-step alcohol conditions because they, as I indicated, some of the most technical, thorough, progressive requirements that I've seen. I mean, they are fairly strenuous, and certainly they were agreed to by these parties, and in another case I had, they were warranted. And I think sometimes I keep the recommendations separate. Well, I do in a separate file that I don't have here, but they should have been journalized. And I'm looking, I think we pulled them out to copy them, and hopefully we got them back into the file, but I'm not finding them. So can somebody give me a filing date? Or Amy, can you tell me where you think I might be able to find her report?
Your Honor,
Judge, that report was in one of the notebooks that was supplied by one of the attorneys on this case. I do know
was-
that.
Yeah, it's exhibit E, Your Honor, mine. Sorry to interrupt you, Amy.
Okay, thank you.
But I think you've summarized. I just wanted to look. There we go. Oh, it's not as long as the report as I thought.
And it's on page 4 of 6 or page 65, Your Honor, I believe
Yeah.
the provision was Locke's referred to.
Okay, all right. Okay, well, I'm still back to where I was in the beginning, which is I am inclined to refer this case to Ms. Langworthy for review to see if there have been any violations, and also whether or not in her view there's been anything that meets the basic threshold of warranting a relook at custody. Those two things. I also have considered, but I've got to look at the statute again. Her being assigned as a case manager. I think these parties, if they don't qualify right now, they're gonna need a case manager.
I think they would qualify if the courts, but I don't, the only thing I don't know, Your Honor, is whether or not Ms. Langworthy does case management.
We checked with her to see if she'd take this case back,
Okay,
just to
okay.
begin with. And I think Amy asked her, do you do case management? But I'm not sure. I didn't call her and talk to her. I didn't want to talk to her about this case, independent of counsel, but Amy,
I did specifically ask with regard to case management. Her response was, yes, I would be willing to serve as case manager for these parties should it be ordered.
okay, all right. One of the circumstances in 233508B, but it doesn't quote it. I'm sure you guys probably know it by heart, but I don't. 233508B. I know one thing is successive motions, but I'm not sure it meets that. Yet, maybe we need one more motion is all. Cases in which case management is appropriate shall include one or more of the following circumstances. Private or public neutral dispute resolution services have been tried and failed to resolve the disputes. Other neutral services have been determined to be inappropriate for the family. Repetitive conflict occurs within the family as evidenced by the filing of at least 2 motions in a 6-month period for enforcement, modification, or change of residency, visitation, parenting time, or custody, which are denied by the court. in, I think this is the first actual motion, and it has been within 6 months of the decree, correct? Look at your timeline.
Yes, yes, Your Honor.
Yes,
Okay.
Your Honor.
We don't have two successive motions. A parent exhibits diminished capacity to parent. If the court or hearing officer orders case management under subsection A, the court or hearing officer shall appoint a case manager taking into consideration the following. So,
Your Honor, if they went back to Miss Langworthy for DC to resolve the
yes,
existing issues, could she make a recommendation to the court as to whether or not she thought case management was appropriate for the next step?
possibly. I mean, I think it still's got to meet the statute. So I'd have to kind of figure that out.
At that point, they would have gone to a neutral dispute resolution service twice with Miss Langworthy,
Yeah, I would agree.
which would be B1.
Okay. Yes. I can't imagine her saying not, but maybe. So maybe these parties will call a truce, but I'll tell you what, I know you understand this, Ms. Locke. There's certain buzzwords and there's certain things that come up that the court can't make mistakes on. And that's issues of safety. And that generally involves alcohol and potential drug use or physical or sexual abuse. So those are the words that make me extremely nervous about making wrong decisions and having a bad outcome, as you well know, as any attorney knows. However, I have a lot of faith really in Ms. Langworthy in the way in which she worked with these parties and the way in which she crafted her report and recommendations. And so I want it to go back to her, and I'm going to ask Ms. Locke that you prepare the order as DC, but I want specifically her to look at, has there been a violation of the original recommendation or orders of the court? Does it appear that there are circumstances that have evolved since her report and or the final hearing, and give her a copy of your Exhibit 1 because she understands the law in that regard, that even meet the threshold of reconsideration of custody? And does she believe this is a case for case management? And obviously I have to be the final arbitrator. So, but I would like some opinions from her. And then we can still litigate the issue of is the court even going to reopen the matter for custody litigation?
Your Honor, in our responsive pleading, we had a section requesting a return to DC and outlined several parenting concerns that my client has. Is it appropriate to ask Ms. Langworthy to also review his specific concerns, or are we going back solely on the respondent's concerns?
I think the basic questions have to be answered first. And then if she's recommending case management and I deny reopening of custody litigation, then they can go to her for case management for any concerns they have.
Understood.
So I think that's the avenue I don't want to get this too convoluted. I want this to be pretty succinct. I almost would like you two to get a transcript of your arguments today, a transcript of this hearing, although, well, we don't have a court reporter, but it would be kind of nice if she just, all she would really need is your motions, the transcript of the hearing, and some limited exhibits, but,
Judge, my concern about the transcript of the hearing is the things that were stated on the record, which we obviously believe are not true, would
okay,
come across as,
okay. All right. Well, then I guess we leave it as, do you guys want it to just be nothing? She gets nothing but talk to the parties? Or do you want, and you have to let her know if she can do any independent investigating and of matters, which, you know, I would want her to look at the exhibit. She would need to look at the exhibits.
Yes.
So I
Yeah, I will.
suppose what it should be is their motion, their exhibits, your response, and your exhibits.
but
From-
Judge, we weren't given, my understanding of the court's position today was what we provided in Exhibit 1, which was just an outline of why the case shouldn't even go forward. We didn't provide exhibits countering their exhibits, frankly, because I got their exhibits yesterday and I didn't anticipate that would be the case. My preference would be if Ms. Langworthy spoke with the parties and believed she needed additional information, that she could reach out to Mr. Olson and I, and then we could then provide those things to her.
Okay, that, but I can't let her have your Exhibit 1 and nothing from him.
But the only thing I would say is that it may cut down on time if we could give, I mean, I don't anticipate we would have anything more than the exhibit notebook that we provided today, Your Honor. Obviously understand Ms. Locke's gonna want the opportunity to provide information as well. I was gonna do whatever the court says, but I'm just assuming Ms. Langworthy is gonna talk to the parties and then want the exhibits. So if we could head it off and send them to her up front anyway, I'd be fine. If Ms. Locke wants to put some exhibits together and send them, I don't think that's an issue for me, but
I'm gonna let her have the benefit of the motion, and we will forward our copy of the exhibits, or you come get them, Mr. Olson.
yes, ma'am.
Have them
Yeah,
delivered to her, and Ms. Locke, if you could send her a copy of your exhibits. I do think she needs to look at this documentation that they claim they got after her recommendations, and after, I know you said there's a time period in there from January to April where they could have been reviewed and brought up, but it is possible that she didn't sit down with them until after. Those AHA documents, I think she needs to look at and say, are these AHA documents, or can they be explained? Or are they even indicative of anything? I really do want some of her opinions. If you want to continue to litigate it, I guess we can through counsel, but I want some overview opinion from her on whether or not she thinks there's been any direct violations, and whether or not there's any evidence that's indicating that there's violations or should be consideration by the court of modifications. So that's the best way. I mean, to have her look at things and statements and mom referencing documents that she says she's now gotten a hold of and studied and seen, and then Paula not to have those, I don't think that we can end this thing once and for all. And I do want a line in the sand. I do want to end this thing with a line in the sand. Because then it starts becoming an issue of parents just not being willing to co-parent. And that's a different matter altogether than what's in the child's best interest. So, okay.
Are you,
think-
Judge? Sorry
Yes,
to interrupt you. Since your stuff next Thursday, are you okay if I wait to pick that stuff up Thursday, or would you prefer to have me send somebody out? Because I would check with Paul's availability, but as far as
however,
the,
I'll just
Okay.
let you and your
Okay.
staff figure it out through Amy.
okay,
And
sound
I'll
good.
put it back
Your-
on the desk. I
Your
haven't.
Honor.
even gone- Yes.
Sorry, I didn't mean to interrupt.
No.
So can I provide exhibits or no? Just
Yes.
our one exhibit, or do I get to provide additional exhibits that we would have presented had we taken evidence?
Yes.
Okay,
Gonna provide those.
okay.
I just didn't want to make you have to give me a copy that I'm not gonna look at right now. If you wanted to just, for expense wise, just do one to her. And then you can give it to me at a later date if we have to schedule something, or if we end up in some kind of evidentiary hearing where you want to use them. That's all. If you want to do 2 copies and send one over to, well, I'm not even going to keep Mr. Olson's copy, and I haven't even looked at him. So really, actually, it'd be pretty fair across the board if you just send your exhibits directly to her. And then we can get them for her, for me, or you guys can duplicate it. I mean, whatever you want to do or your clients want to do, but I was just suggesting that this, just go ahead and go to Miss Langworthy in the form that it's in, and you have copies to look at, so you know what's being submitted by them to her.
Yes, Judge.
Okay, all right. Well, I hope that she can get you in, y'all in quick.
Would it be possible to set this for a status just so we have?
Oh,
some
yeah.
Benchmark.
Yes, good
for-
idea.
Yeah, I'm just trying to think. I was trying to think. I've had a couple of independent cases because of the tuition hikes and all that kind of stuff. And so I was trying to think if there was, I was trying to think, is there any urgency to anything as it relates to anything? And I don't think we have any school issue or any issue. So I'm thinking 90 days probably. I hope she's concluded some things sooner than that, but I don't think 30 is enough.
Hmm.
So, okay, today's 31st. 1, 2, 3. So again, I think we're looking at the end of October. Amy, we set something, special setting, the Vanderford case for the 27th of October, but that's a day
Yes.
before a jury trial.
It is.
On my calendar, what are there cases there you can look at that may very well go to jury, or can you tell?
Judge, we only have one case set there, and the guy is on bond currently. I'm sure we'll have other cases go there that'll be for plea stuff, but that's the only case we have set.
Right, or we could have, it's just July, we could have more juries set there.
Correct.
But
Correct.
let's go ahead and then do this from at 10 o'clock. If that works for council on Monday, October the 27th, 10 a.m.
It works for me.
Okay,
And
so
just go
Amy,
until like noon.
yes, we'll use 9 to noon for any domestic matters that we need scheduled. And then we'll do 1 to 5 for any pretrial stuff if we have a jury go.
Okay, well, that takes up that entire morning between these two cases. So
Pretty much, unless you want to squeeze something in at 11:30 or something.
And this will be for status, Your Honor. I plan to reflect the date in the DC.
Yes,
Okay.
yes. But I'm gonna allot an hour because I always feel like we need an hour.
Okay. And
All right.
Judge, I think you did say did you designate who was gonna do an order for?
Yes, Ms.
Paula? Okay,
Locke is.
thank you.
Because the Supreme Court rule, sometimes I don't think we're as careful as we should be. The Supreme Court rule really does require that you give guidance to DC on what they can and can't do and what they are and aren't looking at. And Ms. Langworthy's familiar enough that she acknowledges where her limits are. And so I think that we need an order that's not just some form that's real general that doesn't give her a direction based on where we're at with this case. Okay, sounds good. If there's nothing
Thank you.
further today, we are adjourned. If there's a hiccup or something with anything, let me know. I believe, Ms. Locke, this is your motion.
Judge, yes, we filed a motion to settle the journal entry. We believe that the journal entry is accurate to the court's orders. I filed a Rule 170. Mr. Olson objected and filed a lengthy objection. I believe several of the issues have been resolved, but there are a few remaining issues. I will note that on Friday, he filed a response to our response to his objections and also produced 67 pages worth of exhibits. I have not had the opportunity to review those exhibits or discuss them with my client, but we are ready to proceed today and believe that the journal entry is ready to be finalized.
Sorry, Your Honor, I know you can hear me, probably see me. My computer in our conference room has gone back to the opening page. So I've got to try to find a password to log in. I'm sorry, we're having some IT issues this morning.
Do you want to, is this causing any adversity currently to the clients? Do you want to reschedule this hearing when and you can check on your technology, but so that Ms. Locke, you can review his most recent pleading?
Judge, I've had time to review the pleading. It's the massive amount of exhibits that were given to me at 4 p.m. on Friday that I haven't had a chance to review, although I don't believe they're relevant to anything that's going to be before the court. Everything that should be argued today is legal argument related to what's proper in a journal entry and what the court has jurisdiction over.
My thought on that, Your Honor, is one, the majority of the exhibits we have are pleadings. I mean, it's the objections, the replies, the notice, it's the transcript from when we put this on the record. There's a proposed child support worksheet. And then the other things are health insurance verification, tuition payments that my client's been making throughout this year that she's not been reimbursed for. So none of these things are a surprise. The only thing that could be quote unquote a surprise are there's some images from Nigeria, where my client's family lives, that we have provided because there's been a pushback and a disagreement with respect to adding verbiage to the journal entry that would allow my client to travel to Nigeria with the minor child to see family because she's from there. So we've included a couple of 2-minute long videos, and then there's a couple of videos of Isabel playing with some cousins and whatnot from Nigeria. And so those are the only things that have been included. So, I mean, our preference would be to try to get this resolved. You know, I don't think it's a big issue that are remaining. I mean, frankly, that's probably the biggest issue outstanding, is whether or not there'll be language that allows my client to travel to see family there. Again, because she's from there, and then there's no plans to travel to date. It's just something that we want to have the option to do in the future. So that, I mean, the other outstanding issues are that whether or not my client who's carrying secondary and health insurance for minor child, whether or not that would be included on the child support worksheet, which we think is appropriate. And then the adoption of that child support worksheet. And I mean, then there's some other cleanup housekeeping items, such as some additional personal property that we wanted to include on behalf of the petitioner within the journal entry. And then there were some other changes, but I think Ms. Locke's already agreed to those, which again, I would categorize those changes as being common verbiage that when you settle a case in court, it's virtually impossible to get that language in every single sentence that's going to be put in a journal entry memorialized on the record. But they're common housekeeping items that you are included into a journal entry for purposes of getting a case resolved. So again, this has kind of been a holdup, I think, for both of the parties to try to get closure. So we're ready to proceed. And again, I apologize, I'm having issues this morning. I've got a text out to get my screen back on, but at least we can still hear.
Well, I need you to explain to me, Ms. Locke, the benefit of secondary insurance in this case.
So, Your Honor, we submitted a child support worksheet to Mr. Olson with my client covering health insurance, which in the temporary order, he was ordered to cover health insurance. So he has been, since the parties separated, providing health insurance as the primary provider since the temporary order. So since this case started, it was agreed that he would continue to provide that. So he has continued to provide it. So it was included in the child support worksheet. Miss Warren took it upon herself to get secondary insurance coverage. Since this case started, she's had 3 different employers. My client has had the same employer, so he continues to have the same insurance coverage. She's had 3 different coverages. We're not opposed to her having secondary insurance coverage, but I don't understand why she should get a credit for that on the child support worksheet. This is not a best interest of the child question. It truly is an order to allow for secondary coverage, which no court is going to say you can't have secondary coverage on your child. But she shouldn't get a credit on the child support worksheet for providing insurance that she has no obligation to provide. And really, that has been one of the primary hangups that has resulted in this trickle down of her paying additional tuition, things like that. So our preference is that the child support worksheet be ordered consistent with the order, which is my client provides primary health insurance coverage and gets the credit on the child support worksheet for that.
All right, Mr. Olson, explain to me why your client is so adamant about having this coverage.
Well, hers is cheaper, Your Honor. So obviously, normally the analysis we go through is what not call it an analysis. It's not even really that. It's somebody's got cheaper health insurance. Why would we not be saving everyone money and using that instead of trying to fight over that issue? Because as Ms. Locke has set out, there's been at least a little period of time the petitioner's been paying it. We've wanted to include it just because there's never a. But there are times that happen, and I don't profess to have any serious background understanding of both parties' health insurance coverages and what is covered, what are co-payments, what are deductibles, all of those things. But there are times that we all are aware of that happen that insurance A may have less coverage than insurance B, and if you process a claim or whatever it may be through both insurances, it ends up costing both parties less money. The reality of it is, Your Honor, the court has the discretion to allow this within the child support guidelines if it chooses. Probably the biggest, if you want to call it, argument I can make to the court about this is it makes a $54 a month difference in child support. $54, that's all we're talking about here. And frankly, I haven't talked with my client about it. But I would suspect even if the court doesn't include it in here, since it is only $54 difference in child support, she's probably still going to provide the coverage. I just think it's more appropriate and fair to have both of them on there and have both included with the child support worksheet. And maybe to get a little sidetracked, but again, my client's paying a lot of money for tuition for the minor child to go to private school. That was agreed upon. She's done that. The minor child's attended private school and have been doing that. That's not something new. And so the point being, this child support is important for her because it does subsidize those payments, those tuition payments. I mean, even in the last couple of weeks, there's a $500 fee you have to pay that's in addition to the tuition that's paid every year, to reserve the child's spot There's another $750, I think, that was the initial payment for this upcoming school year. So anyway, there's a lot of costs, which my client's been paying throughout 2025 without any reimbursement to date. So again, sorry, I'm getting sidetracked, but it's such a nominal amount of change in the monthly child support obligation. Why would we not include it? And the court has the discretion to do that. And my client's health insurance is not unknown. You know, she's had health insurance coverage. The dispute has come is that she's had, I think, two jobs or 3 jobs during the pendency of this case. And so the claim is that, well, she moves jobs a lot. We don't want the fluctuation in insurance, or she may not have it, whatever it may be. But her health insurance coverage is cheaper. The court has the discretion to include it within the child support worksheet. And it's such a nominal difference in the monthly obligation. Why would we not have it included?
All right, Ms. Locke, how much is your client getting as a offset for his premium for the child?
Just one moment, Your Honor, let me pull that up. He pays $331 for support. And Matt and I might have actually discussed that. Let me just say. $274, sorry, Your Honor, there was a change in support that Mr. Olson and I had already discussed. So he is getting a credit of $107, paying the $274, and then he ultimately gets a portion of that back on the worksheet.
Well, how much is just for the child and how much is for him?
That's just for the child. The $274 a month is just for the child. It's medical, dental, vision.
Mr. Olson, is hers medical, dental, vision?
Yes. Yes, Your Honor.
Does she pay less as a secondary insurance or the same amount that she would pay if it were primary?
I think it's the same amount, Your Honor. And we did provide, for what it's worth, an Exhibit F, and I understand Ms. Locke's got an objection, but there's a breakdown of the health insurance coverage monthly for my client. But it's the same regardless. Sorry, that's to answer your question.
Your Honor, may I briefly respond to Mr. Olson?
Sure.
So the child support worksheet that was drafted and provided almost immediately following the hearing takes care of the tuition aspect. It has him cost sharing in the tuition. Rather than adopt the child support worksheet that was provided with this discrepancy of $54 for secondary insurance, which would have shared in the tuition payments, we're fighting 3 months later about secondary insurance coverage. So there's this argument that somehow she's been burdened by these tuition payments, but it's her very own argument about secondary insurance coverage, which she is not ordered to provide, that has prevented the child support worksheet from being ordered. So the challenge that we're having is we want this case fully resolved, and we're ready to get it fully resolved. But she is not ordered to pay secondary insurance. She's not ordered to provide that coverage in any way. My client is, it's included in the child support worksheet. So is the school tuition. So the child support issue should be a non-issue and it should be resolved.
Well, counsel, what I don't have before me, what normally I would do or ask you to do is normally I would look at how much is the premium, how much is the out-of-pocket, how much is the out-of-pocket copay max, how much, what kind of prescription coverage is there, what kind of dental, what kind of vision, and I would compare both policies to see what you get the most bang for your buck. So it isn't necessarily how much the premiums are, as much as overall, what is the best policy for the child?
And it's never been an issue. It's never been a question. Throughout the whole temporary order, my client has provided the insurance coverage, and there's never been a question of what's the deductible? How much will this pay? Her insurance provides X. This only came up post journal entry, like post providing the Rule 170. That is the only time her insurance has ever been discussed in this case.
Your Honor, I would say, well, Exhibit F, base stamp page 60, does have a breakdown of my client's, it's a $2,000 deductible. So it has a little bit of that information. It's a $63, well, I'm sorry, there is a bigger breakdown too, as far as eye exams with the copay, and some additional information on the dental portion of it. I don't think it's quite what the court was asking for, but it does provide a little bit of a synopsis of that. Your Honor, I mean, January was long enough. Yeah, I can't specifically tell the court. I recall whether or not we discussed this or not. I know one put on the record, but I was also reiterate that there are a number of what I would categorize as, you know, not substantive, but maybe side issues or things such of this nature that either are briefly discussed or not memorialized when they're particularly put on the record. You know, it's a very difficult task for you know, not only in court, but for both of the attorneys to get every single possible, you know, either scenario or provision that comes into play when you're trying to resolve a divorce, and to get every single one of those put on the record. I mean, my client's always had health insurance throughout the duration of it, and I believe the minor child's always been covered under her health insurance as well. So again, I'll go back to the fact that this is a $54 a month difference in child support. And it's good coverage. It's cheaper, again, than petitioners. We're not asking that my client be the one to provide health insurance now. We don't consider petitioners. We're just asking for it to be included as secondary insurance coverage, and that it just be included on the child support worksheet as well.
The other thing I could do is just say they both can pay for the insurance, and nobody gets a credit for anything on the worksheet.
Absolutely.
But the problem is then I have to order them both to provide insurance, because I can't run the risk of each one of them saying, well, forget it now, I'm not gonna pay, and then the child have no insurance at all. What is the breakdown of unpaid insurance? Or is it 50-50, or is it based on worksheet percentage?
For unreimbursed medical?
I'm sorry, Susie, I didn't hear you.
Sorry, Judge, are you asking about unreimbursed medical?
Yes, uncovered.
Yeah,
Sure.
it's based on the worksheet percentage.
92.
Which is 30, it's 40-60 essentially, or 39-61. Mr. Warren being the 39 and the respondent being the 61.
Well, I'm not going to give her credit for the secondary insurance because I'm not ordering that she require it. But the split's going to be 50-50 for any uncovered medical. So if she wants to have it so that it reduces any potential exposure for out of pocket for her, that's fine. If she doesn't, then he doesn't get the benefit of her secondary coverage in terms of him paying 39%, he's going to pay 50%. So it's a 50-50 split. Now, Ms. Locke, I'm going to tell you my theory behind some of the decisions I make when I make them, as best I can, if it makes sense to you. And then you can explain to me, I mean, I understand your objections to going to a country that has a, you know, level 3 or whatever alert. But my position has been on a lot of issues, whether it be where parties can live, whether it be who children can have contact with. It happens a lot in paternity actions where the parties never really live together and never co-parent because sometimes they never even spent much time together. But I take a position that there's certain things that you do in life that you enter into that you know or you should know are part of the relationship. In other words, if you marry someone that is from a foreign country, or her immediate family lives in a foreign country, and you know that when you meet her, and you know that when you marry her, and you know that when you have a child with her, your expectation should be that child is going to travel to Nigeria and have a relationship with the mother's family. Now, this is not just specific to you. I have cases where someone is from Mexico, or someone wants to move closer to their family after a breakup, and the other party acts as if, you know, there's no family ties or no reason that the person would take the child there. I look at, what did you know about the person and the relationship when you entered into it? What did you know about the circumstances, the entire circumstances of the situation when you had a child together? And what could you reasonably expect may come of that? And to me, this is one of those things that your client should know, that he had a child with a person whose family, and I don't know if she's actually dual citizenship or she was born in Nigeria. I don't know where she was born, but the point is there's immediate family there. That is part of his daughter's culture. It's part of her background, and it's part of her history. And so I'm not sure why he's objecting. There's no evidence that she is threatened to run with the child. She has a good job. She got a great education. She's a pharmacist. Why would she throw all of that away? I mean, I understand your argument about The Hague. I understand your argument about there are certain areas that are high conflict that are more dangerous than others. But when you put it in the perspective of, this is a child who is equally from the mother's heritage, background, nationality, and the child has a right to explore the country that her grandparents are from, or whatever the case may be. I know I'm probably not being accurate with all the particulars, but the point is, I'm not, now that he's divorced from her, he can't just erase what he wants to erase from his child's life.
May I respond, Judge?
Yes.
And I 100% agree generally with the court sentiments that that's not an aspect of a child's life or the history that should be eliminated. Our challenge here is the parents have never gone to Nigeria together. They have gone to Ghana. We have specifically stated that we have no issue with Ghana. There's no concerns about that because the parents have been there together before having children. That is where the respondent generally lived, is my understanding. She was born in Nigeria, but never actually lived there. The respondent, to our knowledge, in 12 years has not been to Nigeria. Her father, who lives in the United States, does not have a relationship with his family. He does not go back to Nigeria. The concern is that there aren't true connections with Nigeria. There might be family there, that the bigger connections are in Ghana, and that Nigeria is not part of the Hague Convention. And I appreciate the court sentiment that this mom has never attempted to take her child. But for the first 11 days when this case was pending in August of 2023, she took the child from my client, would not tell him where she was, would not allow any contact, would not answer phone calls. So while it's accurate that since then they've been able to work through these issues, that is a serious concern. And the idea that she could, in a 14 days drop of the hat, get her daughter the 10 shots that are required to travel internationally and go to a country that she has limited ties to and that she would have no obligation to bring the child back from, that's a huge concern. There's no concern about sharing the culture, about encouraging their daughter, Isla Bell, to participate in the culture and with the family. But we think that can be done in a much safer mechanism, especially in Ghana, where we know the respondent has ties, that is a party to the Hague Convention, and that can allow for that travel to Africa in a much more safe way.
Mr. Olson?
Well, number one, my client lived in Nigeria till she was 7. Her father's family is from there. They own land. And again, I understand that Ms. Locke has a running objection with respect to exhibits. The 2 videos that the 2.5 minutes in length roughly that we provided with an individual driving around in Nigeria are from her father. So he's commonly there. And again, my client lived there till she was 7. The other point, at least during the issue brought up at the beginning of this case being filed, I was not the attorney of record entered. I don't think it's worthwhile to rehash things from 2 years ago, especially when we're at here now. But Judge, there was never a request that the minor child's passport be kept away or locked up in a safe, or the common ways we deal with situations in a divorce where one parent is from a country that's not part of the Hague Convention and there are legitimate concerns that that parent may flee. It was never brought up remotely during the pendency of this case. It's only being brought up now. The parties didn't travel to Nigeria when they were married because, one, they were only married for 5 years. Travel there is not just a, hey, let's go for a weekend, or frankly, even for a week. It's on the other side of the planet, and it takes, usually those types of trips, you have to schedule a significant amount of time. I would tell the court right now, my client doesn't have any trips planned to Nigeria in the foreseeable future with the minor child, but she wants the option to be able to do that. But again, the child's had some relationship and some time with cousins that have come here that she spent time with. That's another video that we provided. The other video shows the minor child, learning her native language and singing a couple of songs from that native language is very important. And I mean, the court's already kind of hit on, the other, I think, big aspect of this that I was going to point out is that, again, my client's a pharmacist. She's put a lot of work in to be here, to have a career, to live her life here. That's not something that she's going to throw away and run away from. So, and again, understanding some of the arguments and comments about Nigeria and it being dangerous, and I mean that goes for any country, frankly. I mean, living in Wichita, Kansas, I think we would all agree is significantly different than living on the south side of Chicago or in Detroit, South Central LA. There are plenty of places in the United States that are very dangerous as well. But we don't prevent people from traveling to go to Los Angeles because there's a high murder rate there, or vice versa with Chicago, which I think has the highest murder rate in the country every year. So the place that the part of Nigeria where her family lives, there are not issues with that any more than what the United States has. As you can see from the videos, it's not a dilapidated, I'm not trying to be disrespectful, but dilapidated third world country. But again, as the court has already said, this is something that you get what you bargain for. You go into this relationship, or you go into a relationship with somebody, and you get what you get the individual you get. And if you're married to somebody that's from a country such as Nigeria, and then you have a child with them, I think it's a little disingenuous in the context of after a divorce, to try to prevent the child from being able to go there to spend time with her family and with her heritage, which I think is extremely important for the development of any child. So, I'm not saying that there shouldn't be some parameters, or that my client's agreeable to, notification and, any number of things, if that helps ease the petitioner's concern before she travels, if and when she does. But she wants to have the option. And I think that that's more than appropriate given the circumstances that we have here. And again, we're asking that the court allow for that to happen.
Judge, can I ask a clarifying question?
Sure.
My understanding of Mr. Olson's position was that in emergency situations, Miss Warren should be allowed to take the child immediately to Africa.
Oh, I'm not gonna allow that.
And that was our primary objection, that in an emergency, there would be no travel to any country that wasn't a signer of the Hague Convention.
I think that there should be a minimum of 30 days notice.
The only response would, I'm fine with that, Your Honor, but if there's a death or something like that, but if that's the court's order, that's the court order. I think we would be fine with that.
And that would give somebody 10 days to file an objection and to get a hearing in front of me if there was something special going on.
The parties had agreed previously to 60 days notice.
Okay, that sounds even better.
Rather than the 90 days, which had already been agreed on in domestic conciliation was 90 days. They agreed to modify that to 60 days. But Mr. Olson was pushing for this emergency situation definition that would allow to travel without any notice, which was our biggest heartburn, was we didn't want any travel to a country that's not a signer of the Hague or any international travel really at all without notice.
Your Honor, my preference would be 30. I think, if there needs to be a motion filed or this needs to be addressed by the court, that 30 days is sufficient notice that we can bring it in front of you.
Well, I
before
could
that
back
to
to
occur.
the 90 if that's what was negotiated. I don't want them to feel like they can just keep raising issues that have already been agreed to or resolved. The problem, I think what I'm gonna do is split the difference, 45 days, because that gives 2 weeks at a minimum for the court to get a hearing. What 30 days is what I'd prefer, but my fear is by the time they get back to an attorney, they have a meeting with the attorney, they file an objection and it's scheduled for hearing. We may be having a hearing 3 days before she's scheduled to travel. And I think 45 days gives enough notice that she can still book things within 30 days. I can't imagine going to another country and not planning it for at least 30 days. I understand about deaths. I don't, yeah, every culture is different, in terms of how quickly, they have services, how long the services are. I have a niece and nephew who are Samoan funerals last 2 weeks. And there's a lot that goes into them ritual wise. So I don't profess to know about all the different countries or, how they have the funerals, whether the body's present, whether it's embalmed. I mean, I just don't know enough. But she's so little too. I don't even know how much they want her directly involved in that kind of thing, depending. I don't know. If there's an emergency, you're just gonna have to file for an emergency request if they can't agree. What if it's 45 days notice, what do you want the objection period to be? Ms. Locke?
Your Honor, their agreement in DC was that you would give 90 days notice, the parties would talk about it, and then consent would not be unreasonably withheld. That was their agreement in domestic conciliation. Now that'll be shortened to 45 days, but I think those same parameters would apply.
Okay. Well, it probably should say any objection to the notice should be no later than 14 days. and the parties can demand an immediate hearing. I want to look at your response, Ms. Locke, again here real quick. What else, if anything, is at issue or do you foresee being an issue?
The only other,
Sure.
folks, go ahead, Suzie.
So the next item that I have is the retroactive application of support. There's never been a journal entry finalizing child support. The law says that support commences at the court's order. And so our proposal is that child support would start as soon as the court's order is entered. And I believe that the respondent's position is that it should be retroactive to the trial date.
The only response I have to that, Your Honor, is my client to date has paid $4,092 January through March. Actually, not to date, that's at least January through March. Now there's some additional costs she's paid, as I mentioned earlier in this hearing, but paid $4,092 for tuition for the minor child. She's not gotten any child support. So that, again, with the goal being that there's an offset to those tuition payments through this child support order, we had requested that the child support amount be implemented effective February 1st. If the court's inclined to do it effective April or May, then again, this is probably even more outside of the scope of what we discussed and agreed upon in January. Then, you know, we're going to ask for some type of reimbursement for the tuition payments that my client has paid. So again, I think it's a lot easier and cleaner to have it the modification be effective, excuse me, I can't speak, February 1st.
And
Well, I'm gonna order it effective April 1st. And part of that is because she wasn't ordered to pay health insurance. So the delay on the journal entry with regard to that was prompted by a desire, not an obligation. And secondly, they'd already negotiated the 90 days. Now, I understand there's some other issues though that you did resolve and agree to from the journal entry. I don't know how significant those were. Obviously, you were able to work that out. But I think some of the delays just been caused by your client not wanting to sign off on everything. And so I'm going to make it retroactive to April 1st.
then the next item, Your Honor, is personal property. The respondent wanted personal property included in the journal entry that my client does not own and has never claimed to own. We objected to those items being included. And then obviously it's now here before the court, but our position is that the court doesn't have jurisdiction over personal property that my client doesn't own, and therefore it cannot be included in the journal entry.
Your Honor, I would say your time. I don't, if that's Ms. Locke's client's position, I mean, arguably to his benefit, including that, we're fine if we leave that out. That's okay.
Okay.
And then, Judge, the only remaining item is there was a late addition to the journal entry proposal that there be some requirement that my client cannot go to Ms. Warren's place of work. The most recent ideation of that is that he is not allowed to go to any Dillon's pharmacy, which everyone from this area knows that the Dillon's pharmacies are in the Dillons. That essentially would be preventing him from going to 16 Dillons in the Wichita metro area. Because she travels, meaning she's not at any regular store. The pharmacy is in the Dillons, and she doesn't want to have any obligation to inform the petitioner of which store she's working in. So essentially the respondent's position is that for no apparent reason, my client should not be allowed to shop at Dillons.
Well, if you're in El Dorado, when Walgreens closed, your only choices are Dillons and Walmart and True Care. So, Walgreens has taken some off the table, but where does your client get his prescriptions? I mean, if he's picking up prescriptions for the daughter, he's going to go to a Dillons pharmacy.
And
This is
and
Wichita, Your Honor. I would just say that. I'm sorry for interrupting.
yeah, he doesn't typically use the Dillons pharmacy, but the position is that he not be allowed to Dillons pharmacies, which are in Dillons. So I don't know how you enforce that other than he can't go in Dillons. The issue that they're alleging happened, he stopped in a Walgreens store after an exchange, during which he had exchanged their child with the respondent's father. And he stopped in a Walgreens store to get some vertigo medication and a drink. And he never even saw the respondent, didn't know she was working there. He did see her father in the store. And then she made this allegation that he was stalking her, which was not true. He simply stopped in the pharmacy to get some vertigo meds and a Gatorade. And now we have this idea that he wouldn't be able to go to any Dillons in the Wichita area.
I mean, that'd be ridiculous. Again, it's not like we have a lot of options for grocery stores, and you usually go to the one that's closest to you, unless you, I don't know, some people shop around so they can go to Aldi's or somewhere and save money. Some people go to 5 different stores, depending on what they purchase, where to save money, and drive all over. I mean, he's going to be allowed to go to the Dillons. And I just understand why, if he just fills a prescription and there are videos everywhere, there are videos all around the pharmacies to make sure people don't rob the pharmacies. If he's conducting himself in a professional manner, and she is too, I don't really see what the problem is. But if it's not his, nowadays people even have to pick pharmacies based on their prescription coverage. I mean, if you have TRICARE, there are certain places you can't go, and they don't accept your coverage. I mean, how can we limit if, again, people are trying to get the most for their money, as they should, and people should be acting in the best interest of their children. So I'm definitely not going to limit him that he can't go into a Dillons store, and he's not even going to know what one she's in at any particular time, potentially. But Mr. Olson, what is your response with regard to him being a patron of the pharmacy itself?
I think one, again, I was trying to avoid rehashing things that have gone on during the pendency of a divorce, because clearly the hope is the parties are moving past that. The event that's been referenced was from May of last year, and the concern my client had is obviously being familiar where the petitioner lives, and in conjunction to where she was working at the time, he would have passed at least two different pharmacies to be able to pick up the stuff that was not prescription based, the stuff that he bought in her pharmacies. The request I feel like is much more you want to say neutral than what's being discussed. It would be that neither party's to be at the other party's place of employment. Now, obviously that does put a little kink in it. I mean, I guess the argument I have for the court is, I think you can still very much be in a Dillons without being near the pharmacy. The pharmacies are all located in the same spot. They're not in the middle of the store. Knowing the layout of the pharmacy in the Dillons in El Dorado, as opposed to the pharmacy at the Dillons at Central and Rock, which is about the size of Town East. I mean, you can very well do all the shopping you would need without having to be near the pharmacy. So I don't think it even needs to be a provision that would ban the petitioner from being in a Dillons store. Just don't be at the pharmacy. because you know she's working there. And I think anybody, if they're cognizant of not trying to create or cause problems, I mean, I think you could very well follow through on that order without violating it. So again, the request isn't that it be banned from a Dillon's, but you know, again, I understand where the court's coming from. I would say there are a lot of pharmacies in Wichita. You know, you've got Walmart, you've got Dillon's, you've got Dandelion, you've got Walgreens, you've got, I mean, and then there's a bunch of mom and pop shops as well. So I don't think it would be any type of real detriment to the petitioner. And again, we're not asking it just apply to the petitioner, it'll apply to both parties, which I think is fair. So, you know, obviously the goal here is not to create things that will create more litigation in the future, which I think is always something I try to do when wrapping these types of cases up as best we can with the court having continuing jurisdiction. The goal is actually the opposite of that, is to try to prevent issues from coming up. So I think it can be accomplished. My client does rotate Dillon's stores. I know that makes it a little bit more difficult, but I think you can very well go into the Dillon's. And again, I don't profess to have been in every single Dillon's in Wichita right now. I think there were a couple of smaller ones at some point in time in the past. I think those have closed down. I think most of the Dillon's within Wichita are a very large or pretty big. You know, I think the one in El Dorado is pretty good size that you could do your shopping without being near the pharmacy. So I mean, that was the basis for the request, Your Honor. One thing I would add, I didn't say, there was a PFA during the pendency of this case. I think that got resolved. Again, I wasn't the attorney of record, but there has been some concerns with, and again, I'm not trying to rehash the 2 years that this case was pending from where we're at now, but there were concerns for my client during the pendency of this case that the petitioner was following her and was in places that she felt uncomfortable that he was at. And it was an attempt to try to alleviate that from occurring, frankly, for both parties as we move forward.
Well, first of all, Mr. Olson, I'm rarely at a pharmacy where the pharmacist is up at the front desk. Sometimes they can be seen if you know who they are, but they're behind the scenes. Secondly, Ms. Locke, if I were your client, I'm not sure that I would want to go to a pharmacy where potentially my ex-wife is doling out my medications. I am not going to restrict him from being in Dillon's. And the other issue, though, Mr. Olson, is, from my experience, occasionally I'll get a prescription for a new med to try that is $300, $400, $500, $600. And so you have to look at where you can get discounts, where you can get coupons. What costs do vary, especially from pharmacies to pharmacies. And so I'm not sure why I would prevent him from filling a prescription at some Dillon's if it saves him money for himself, for the child. Again, though, Ms. Locke, I don't know why your client would even run any risk of her reporting that he is harassing her at work. I hope to see the parties get past all of this. So I guess the order is going to have to say that in order for him to use a Dillon's pharmacy, he is going to have to contact the store manager and verify she's not working that day and pick up the prescription when she's not the pharmacist on duty. But I'm not going to prevent him from being in Dillon's.
So this is only if he's going to fill a prescription at Dillon's?
Yes, because the over-the-counter, there's no way to enforce the over-the-counter meds are adjacent to where the pharmacy is. And again, he may pick up Tylenol for the child, or he may pick up other things while he's at the grocery store. I do think most of the pharmacies have glass or walls. I mean, she's certainly protected back there. They're usually not all open spaces. And like I said, the pharmacist usually isn't at the very forefront of the store or checking people out. If you need consultation by a pharmacist, they may be called and come to the front of the store, but that's not where the majority of their work is taking place. So, he shouldn't be up at the counter filling a prescription on the day that she's working at that particular pharmacy. But he can be in the Dillon stores, and if he needs to fill a prescription at Dillon's, then he needs to show evidence that he called ahead of time and confirm that she would not be the pharmacist on duty at that store at that time.
Your Honor, may we request that she have an obligation to tell us about any job change? During the course of this case, she's worked at Walgreens pharmacies, she's worked at Walmart and Sam's Club pharmacies, and she's worked at Dillon's pharmacies. And so we don't want this to apply only to Dillon. She moves pharmacies and now she's working at his regular pharmacy and we have an issue.
Don't you think for purposes of child support, et cetera, they should give notice of changes in employment?
Yes, but it has not occurred in this case. And so I don't think there's any harm in writing it into the order.
Okay, that's fine.
Well, yeah,
I
Oh,
do
sorry.
think there are certain folks that need as much in black and white as possible. And unfortunately, they're one of those couples, I think. So, Mr. Olson, what were you going to say? I'm sorry.
Sorry, Judge, I just said the court hit what I was saying, so I apologize. I mean, if she's obligated to under the guidelines, if there needs to be another provision in it anyway, I mean, it's reiterating what she's already obligated to do. That's fine. That's fine.
Okay. Now, you two are not operating though on this employment thing. I mean, you're not, right? Are you writing this in as if it's a restraining order such that it's a arrestable offense, or are you writing it in as it could be the basis for contempt?
I would be writing it in as just like a contact restriction that would essentially be a violation of the order.
Okay.
Yeah.
All right.
I don't believe there were any other objections that haven't already been resolved by agreement, but I will let Mr. Olson let me know if I missed one.
No, I think we're good, Your Honor.
All right. All right. Good luck to the both of you. I hope your summer goes well. You have a beautiful daughter. Pictures are adorable. So, and I'm sure she loves both of you. So, I do think I think it's time well spent, to make sure that we have as much, in the decree as possible. And hopefully though there's some guidance to you on any issue that develops, and or, you can negotiate through your counsel. All right. Okay. If there's